system. Well, we have to go back to the prior jurisprudence, no? See, the law providing for the election of party list provided that to be entitled to get a seat, a party must garner at least 2% of the votes cast for the party list, and that it must and it can get a maximum of 3 seats. That's all. If you get 6% of the votes cast for the party, then it will get 3 seats maximum. Now, earlier, the first time that was implemented, I think there were very few parties who got the 2%. So there were only a handful who were proclaimed elected. And that was questioned by those who fell short of the 2%, but came close to it, like 1.8 or 1.87. Because they were arguing that the Constitution provides that 20% of the members must come from the party list, and so that has to be complied with. But the court said no, that provision does not mean that it is mandatory that 20% should come from the party list. In other words, the court said that number merely represents the maximum number of congressmen from the party list. And they said that it was reasonable for Congress to require that to get a seat, a party must obtain at least 2%, because you cannot claim that you truly represent a certain sector if you cannot get a decent number of votes. So far so good. So came along this new ruling of Justice Carpio, which overturned that, said no, that provision, the 20% is mandatory. Therefore, 20% must come from the party list. And he also overturned the requirement that you must, a party can obtain a maximum of 3 seats. So he said, so this is now the formula. Said that COMELEC should list down the number of party list and then tabulate them in the order of the number of votes they receive. You start with the party which got the most number of votes and end up with the party which got the least number of votes. Now, those who got at least 2% of the votes will automatically get a seat. Now, because the court said that old requirement that you must get at least 2%, then it will be mathematically impossible to ever get 20%, because you will never be able to get 20% of the party list getting it at least 2% each, because some parties will get more. So, and there are fractions. So he said, you know, therefore, he said, to comply with that requirement, what will happen? Those who got at least 2% will automatically get 2%, 1 seat. But that is all. They can only get 1 seat. So let's say that 20 got at least 2%, so those 20 parties get 1 seat. Now what do you do? How do you now fill up the remaining 36? Then you go down the next parties. So you rank from the 21st to the 50th. You give them 1 seat each. That is the new formula that he provided. That's why you will notice now there's a proliferation of party lists. I think more than 180. Because now they see, even if we get a handful of votes, because they were saying when that 2% was mandated, there were some party lists, they could not even get enough votes that would allow them to elect a provincial board member. And yet, we went national office. But that is what happened. That's why now we have more than 100 party lists, because they realize even if you get a few votes, you could get a seat. And they are more concerned with pork barrel. Now, of course, the court said that they should represent the underrepresented, marginalized sectors of society. But then, it's trouble now. How do you find out who is marginalized, who is... Well, the court has said that it is easy to pretend that you represent the marginalized society, but then a party must be able to prove that actually, if there is a showdown they will vote in favor of the marginalized sectors. And I do not know, because so many parties have filled it for the party list. There's drivers, security guards, and then these people who lost money in the college education plan, and then even the ladlad. And the court said, yes, they're marginalized. Because that was being questioned, that the gays don't need the party list. They are already adequately represented by the regular members. But of course, they refused to pinpoint who were the representatives. So that's how it is now. And then you have the case of Miriam, Defensor, Santiago. You remember that when Chief Justice Panganiban was retiring, so there would be a nomination for the next Chief Justice. And she applied to be Chief Justice. And of course, some incumbent associate justice like Justice Puno were among those who were being considered. Now, originally, the JBC scheduled an interview for all the applicants. But then they changed the rules, said those already members of Supreme Court, they need not be interviewed. Now, but since Miriam Defensor was not a member of Supreme Court, she was scheduled to be interviewed. Now he said, well, if the others will not be interviewed, I refuse to submit to a procedure where I will be interviewed, but the others will not be interviewed. And so because of that, her application was not even considered. And now she delivered a privileged speech in the Senate, saying that she was irate, that she was spitting at the face of Chief Justice Panganiban and his cohorts in the Supreme Court, and that she would never again apply to become Chief Justice. She didn't want to be in the company of the idiots in the Supreme Court. Now, I think somebody, a lawyer, filed a missive case against her, asking the Supreme Court to subject her to discipline as a member of the bar. Now, she now argued that her speech in the halls of Senate could not be the subject of a disciplinary action because that is privilege covered by parliamentary immunity. But the court said she delivered speech to vent her ire at the Supreme Court because she said that I'm irate. So he said that she just wanted to vent her personal hatred for the Supreme Court, but she attacked the Supreme Court. So that this had nothing to do with the performance of her legislative functions. They said that would be privilege if it was for the benefit of the people or of the members of the Senate. But that is the situation here. She just delivered speech in order to attack the Supreme Court. So the court said that the speech was not covered by parliamentary immunity, but then they did not impose any penalty upon her. Well, these electoral tribunals, you will recall, this was also the Bono Fontaine at Limcaking case, which triggered the indefinite suspension from the practice of law of Justice Reyes. The Supreme Court has repeated the rule. If there was, remember, the election code provides that if a petition to disqualify a candidate was filed, even if the winner has been proclaimed, it should still be continued and decided on the merits. No, but the Supreme Court has repeatedly held that if it involved a candidate for the House of Representatives, if that respondent has been proclaimed, the moment she has been proclaimed, the COMELEC loses jurisdiction, whatever is the stage of that disqualification case. Even if a division of the COMELEC has already ruled that the respondent is disqualified, but there's a pending motion for consideration, the COMELEC loses jurisdiction because under the Constitution, questions regarding the qualification of a member of the House of Representatives is exclusively within the jurisdiction of the electoral tribunal. And that is true even if what was filed was a petition to annul the proclamation of that winner, and the basis is that the winner is disqualified to be a member of Congress.
Now you have this legislative investigations that this involved this general who was involved with bringing euro to Russia, and the money was confiscated because the amount exceeded the equivalent $10,000 and he did not declare it. Now, there have been so many versions on why he had that money. One is that it was given as an advance for possible medical expenses of the members of the team in Russia. And then there was also a claim that this was given by a businessman who asked him to buy for him a Patek wristwatch. But then, so the Senate Committee on Foreign Relations decided to look into this. And this police officer questioned that. He questioned the assignment of the Senate Committee on Foreign Relations to investigate that. He said that it's not the one that should have jurisdiction over this. But the court said the question of which committee will have jurisdiction, that's a political question. That's for the Senate to decide. And therefore the court will not interfere and tell the Senate whom it should assign to investigate. And then it also rejected the argument that the Senate cannot look into this. The court said, you see, the Philippines is a signatory in the Convention against Corruption, and also this money laundering, and the Convention imposes the duty upon the countries to ensure compliance with that, to monitor the movement of money, and therefore the Senate can investigate to see if the Philippines is complying with its obligations under those conventions. Then on executive power, well, there was this case, this Philip Seafoods. They had a, well, when they were new, they were our client, but then later on, I think they became the client of Angara Law Office. Now, they applied, I think, for tax incentives with the Board of Investments, and they got an adverse ruling. Now, the Angara Law Office appealed to the Office of President, the Board dismissed that and in fact, under the Omnibus Investment Code, just provided the appeal should be to the Supreme Court. But then remember, the Supreme Court said, under the Constitution, the Supreme Court cannot be given appellate jurisdiction over a case without its consent. And that is not with our consent. So the appeal should be to the Court of Appeals. Now it was the Angara Law Office argued, but the Constitution says the President has control over the Executive Department, and therefore the appeal should have been entertained by the Office of the President. But the Court said no, that power of course is not absolute. The power to review the decisions of subordinate Executive Department with power of control is not absolute. It can be restricted by the law, by the rules of court, because the Supreme Court has the power to promulgate rules of procedure, or by the order of the President himself. And but that cropped up again in the case of this Judge Angeles, who filed the case for libel, went all the way up to the Secretary Judge. Secretary Justice ruled that there was no probable cause. Now, she appealed to the Office of the President. The President rejected the appeal because under the administrative order, it was provided the Office of the President will only entertain appeals from decisions of Secretary of Justice if the penalty for the crime involved would be reclusion perpetua or life imprisonment now, but that has been abolished. And but no, the Angeles brought this up Supreme Court because the President has the power of control over the Executive Department and therefore the power to review any resolution of the Secretary of Justice involving criminal cases. Now, the court said, well, in effect, I'll just elaborate what the impact, what the court seemed to say, I think, is that the Constitution gives the President this power. But it does not mean that he has the duty to review every decision of every cabinet member. The court said, if you will do that, the idea of having cabinet members, the cabinet system, precisely, so that the President could farm out his functions to these people who are his alter egos, so that presumably their actions bear the approval of the President, as the President gave them, would be nullified. In other words, the President will have to review the action of every cabinet member, and you will fritter away his time. Imagine if it's a petty crime that was brought up to and so the President has the discretion to say that I will not review the decisions of my alter egos in cases like this. Now, the only important decision Supreme Court on would be the power of judicial review. Well, again, the court reiterated its previous ruling that only the judiciary can declare a law unconstitutional. That admissive tribunals do not have the power to declare a law unconstitutional. And as you know, the requisites for judicial review is that there must be an actual controversy. The one raising it must have standing. The constitutional issue must be raised at the earliest opportunity. And lastly, it must be necessary to resolve that issue to decide that case. Now,
determination of constitutional question constitutes this.
well, you see, remember that there was this move to amend the Constitution. And the House of Representatives passed a resolution which would saying that Congress should convene at some future time to propose amendments to the Constitution. And the question is, because one of the questions being raised is in discussions is that how do you determine the 3/4 majority? Should the two houses vote separately, or will be 3/4 of the two houses voting jointly? Or suppose the Senate refuses to participate. And so Lozano now, because of that resolution, went up to the Supreme Court as a court to decide that issue, whether or not the House can act unilaterally, or whether the 3/4 could be based so that if the 3/4 would, if you add the senators and the congressmen, the majority approving the proposal in the House would be 3/4 of the combined members of there would be a valid proposal to amend the Constitution. Well, the Supreme Court threw out the petition of Lozano. It said that it's premature. They only said that, the resolution is not yet calling a joint session to propose amendments. They just said to consider in the future. So there's no actual controversy yet. In fact, they reprimanded this Lozano for filing frivolous petitions, wasting the time of the court. And then, remember this case of Jambi. Well, she invoked the ruling in the Gingona case. Remember the Gingona case, the court said that the representation commission should be proportionate to the party alignment, and that if there's a fractional seat, like 1/2 seat, you should not round it off and make it 1 full seat, because there will be overrepresentation. And now Jambi decided to question the composition, because despite that rule of the Supreme Court, in actual practice, the Senate has been violating that, but it's just that there is an agreement that nobody will rock the boat and question it. But Jambi questioned it. But the court said, again, it is premature because the records show that you have requested the Senate to revise the composition. And that has been referred to the Senate President. So it's premature. You see, wait, what will the Senate do about your request? And then the party representatives have standing. Now, I mentioned to you yes about this ordinance in Manila, which prohibited letting out a room more than twice a day, once it is for a short time. Now, the one who questioned it were the motel operators. So the question, do they have legal standing? Well, the court said, well, they would have a legal standing because first, the court said, the person who is not, well, first the court said these motels would be injured because of that, their profits from the operations of their businesses would be adversely affected. And the court also said, when there's an issue of transcendental importance, a person can raise the constitutional issue even if someone would be more directly injured. Yeah. Well, because there's a close relation to the third party directly injured, or there's some hindrance of that party to file the case, because you could not expect a customer to go to court and saying that, you know, I have been prevented from going to the motel on short time basis. Likewise, in the case of Jambi, when she questioned the allocation of seats in the commission appointments, the court said, you're questioning the allocation of seats, but there's no allegation that you and your party are adversely affected, that you're being underrepresented. So it's the one who is underrepresented who can even raise that issue. Supervision over the courts. You remember that in that Maceda versus Vasquez case, the court said you cannot file a criminal case against a judge. It is connect performance of his duties, because that would interfere with the exclusive power supervision of the Supreme Court over the judiciary. That what should be done is that the Ombudsman should refer that to Supreme Court, so Supreme Court can first act on an administrative basis. Now, there was a judge who was charged with reckless imprudence resulting in homicide, and so he questioned the filing of that case. He was invoking the doctrine laid out in Maceda versus Vasquez, but the court said you cannot invoke that. The offense which is involved in the case filed against you has nothing to do with the performance of your duties, so that entertaining it will not interfere with the power of supervision of the Supreme Court over the judiciary. Civil Service Commission, when the Supreme Court reiterated the ruling last year that the civil service can entertain missing case against presidents of state universities, because the court said that although they do not belong to the career civil service, they are part of the civil service system. And it's the Civil Service Commission that is in charge of administering the civil service system. Then, in this National Power Corporation, remember, under the PIRA law, it's supposed to go out of business, and the law provided that the employees should be given retirement benefits equal to 1.5 months salary for every year of service. And so they were paid that. But now they want to claim benefits under another law on top of that. Now the court said no. Remember, the Constitution contains a prohibition against double compensation unless there's a law specifically authorizing it. And so the court said your claim cannot be entertained because it will violate the provision of the Constitution. Now the court has said, remember that it is the decisions of the COMELEC and bank which can be brought to Supreme Court. The ruling of a mere division cannot be brought up before the Supreme Court. Now, there have been a number of cases involving pre-proclamation courts as well. A division dismissed a case. For example, they said, the appellate docket fees will not paid. Therefore, we're dismissing case. The motion for reconsideration is filed. And then the division will also deny the motion. The court said, when a motion for reconsideration is filed, it's the COMELEC and bank who must resolve it. The resolution of the division would be null and void. Now, but when it is an interlocutory order, you cannot, if you file a motion for reconsideration, that will not be referred to the COMELEC and bank. It is the division also who will resolve that. And therefore, if the party who is aggrieved wants to bring it up Supreme Court, then he should bring it up within the period applicable to the under Rule 64 on the basis of the denial of the motion for reconsideration. The local governments, the only issues decided involving this, well, of course, aside from the creation of the new cities, the free term limitation. There's a case where somebody became mayor, ran for mayor, then during one of the terms, he was disqualified. But he was granted and he was running again, and the opponent was claiming that he's bound by the three-term limit. The court said no. In one of the terms he was disqualified, so he did not serve three terms. Now, there was a case where somebody was barangay chairman, for 3 terms. In one of the terms, he ran for municipal councilor. Now the court said that is voluntary renunciation, and therefore that is included in computing the 3-term limit. That is different from the case where the mayor died, the vice mayor became mayor, and so the position became vacant, and so the council, the highest number, became vice mayor. The court said there that term will not be included because he did not serve it for a full 3 years. So he could run again as councilor. And the court said because his assumption of office vice mayor was involuntary by operation of law. He was mandated to assume that office. Well, that's a criminal offense under the revised penal code. If he will not. Well, let's be at the counterpoint. I think the court has reiterated the rule. This is a pick-up. Remember, they had this temporalized agreement, I think, in this league. And then, after 25 years renewed, and now they want to renew it again, renew it once more. But the court said the Constitution provides you get any agreement to exploit natural resources, maximum duration, 25 years, renewable for another 25 years. So you have had that concession for 50 years. So you cannot extend it. Now the Supreme Court said the corporation, which is 60% Filipino-owned, can own private property because that is authorized by the Constitution. But you have this Stratcom case. What happened is that this CDCP, which became PNCC, Philippine National Construction Corporation, had a, I think, subsidiary, and they obtained foreign loans for that subsidiary. Mitsubishi, it was only 20 years ago. They have not paid. Now, what happened? The present board passed a resolution providing it was acknowledging that it was indebted to PNCC, to Mitsubishi. And then, what happened? Mitsubishi assigned that indebtedness to a corporated shell from British Virginia Islands. And then, this company now filed a case against PNCC. And PNCC entered a compromise. Under that, it would assign, by way of dasyon and pago, 13 parcels of land and future earnings from collection from the tolls, the South Superhighway, so that this would reach, I think, over 6 billion pesos. But that's why the Supreme Court nullified this. That debt had already prescribed. Why did these directors pass that resolution declaring that it had this outstanding obligation? And on that basis now, Mitsubishi assigned the debt, which was $2 million, I think, to this BBY Corporation, which now sued. And now, there was a compromise. when it would collect billions of pesos. And the court said the assigned property should be void because that's a foreign corporation. It cannot own private land. So this is the biggest scam so far we have come across. Then public corporations, well, they give that case where there's a boundary dispute between Makati and Pateros. Well, the court said it's a boundary dispute involving a highly urbanized city and municipality. And under the local government code, it's the regional trial court which would have jurisdiction over that. On the other hand, there was a boundary dispute between Lanao Norte and Misamis Davao Oriental and Lanao involving a Davao Oriental and Surigao del Sur. It involved a area which has mining resources. Now the court said it's a boundary dispute involving two provinces, and under the local government code, that should be resolved by the Sangguniang Panlalawigan of the two provinces. And if no satisfactory solution is reached, then that is when you go to court. Then, regarding disqualification, the residents, well, there was a married woman who was running for municipal mayor. And then the court said the evidence showed that because the opponent was saying she's not eligible, she wasn't a resident. The court said, well, the husband has fixed their conjugal dwelling in another municipality, and presumably they're living together and not in this place. You know? So the court said she's not a resident and could not run. And then that you must be a registered voter. There was a case where a petition to disqualify somebody was filed, and she said, no, I'm a registered voter. But the court said there was, in fact, the application is dubious. The court said your application for registration is unsigned. And then the portion where the admitting was supposed to acknowledge that he admit the oath to you is also unsigned. So actually you're not a registered voter, and so you cannot run.
Chicos, boboto ka? Boboto ka?
Although there was this case where Tagaytay City assessed a piece of property, I think 2 lots there, for non-payment of real estate taxes, and then auctioned them off, and then bought them for the auction, and then consolidated title its name, and then eventually disposed of it, and it was bought by the family of Justice Amorpina Herrera. Now, there was a litigation, and the court nullified the title of Tagaytay City because they said that property is not in Tagaytay. It is part of a municipality in Batangas. So you have no jurisdiction to assess it for real property tax and auction it for non-payment of real property tax. Now, the court said that is in the technical description of the territory of that municipality in the law, creating it. And everybody is presumed to know the law. Therefore, you were in bad faith. But, so the court said, you have to return the property and then it has to return the money paid by the Herrera family with the interest, and also the court awarded moral damages and exemplary damages is the bad faith. No. Well, I mentioned to you yesterday that the Supreme Court said under the revenue codes provided, the bracketing of excise taxes on cigarettes based on the fair market price, it cannot be changed. What? Because precisely Congress said we don't want a situation where the BIR will have discretion to adjust the bracketing. So any change can only be done by Congress. And the BIR came out with a regulation allowing a resurvey, and then they resurvey the market for the cigarettes being British American tobacco, and they lower the tax. So the court said that regulation is void. Now, of course, you have this doctrine of exhaustion, there's remedies, and there are exceptions to this. There are two cases decided last involving the exception. First, where there was an operating contract for a mining company, and there was a dispute, and that was submitted to arbitration accordance with the law. But the court said the issue involved here is not covered by the provision of arbitration. So the arbitrators had no jurisdiction. And so the action is patently illegal. Therefore, you can go to court without need of exhaustive remedies. And then in the case of Mandaluyong, they renovated their market, and now they were notifying the vendors in the old market, you have to apply to get a stall in the new market, and they revised the fees they would have to pay. Now, these vendors now went to court, and they were claiming that the issue is whether or not they are claiming that the local government code provides that if you're going to raise the fees you're charging, there should be a public hearing. And you did not conduct a public hearing. And the Mandaluyong was arguing you did not exhaust the remedies. But the court said the issue here is purely legal. Is the adjustment of fees valid when you did not conduct a public hearing? Then you have the doctrine of primary jurisdiction. This is where we stockholder who ask to inspect the corporate record. The request was denied. And so I filed the case with the SEC, it was time with the second jurisdiction over the matter, to compel the allowance of the inspection. And then a criminal case was also filed against the responsible officer who did not allow the inspection. Now, it was argued that because of the doctrine of primary jurisdiction, the criminal case should be dismissed because there's a pending case to compel the corporation to allow inspection. The court said the doctrine of primary jurisdiction cannot be invoked to prevent the filing of a criminal case, so that simultaneously that case could be filed and also this criminal case can be maintained.
Doctrine
Then public officers, well, you have that case. He said that this Attorney Remolyo was elected mayor of Dumaguete City, and he lost when he ran for election. And before stepping down from office, I think he appointed about 89 people. He filled up all the positions there. But the Civil Service Commission, I think, had a circular prohibiting a local official who ran and lost from making appointments. And now these appointees are now suing for payment of their salaries. But the court said, no, your appointment was not valid because they were revoked by Civil Service Commission. Then, as you recall, that abolition of office to be valid must be made in good faith. So when a new mayor came in one place, I said he's reorganizing the set up in the municipality, and then one incumbent was terminated, and then they replaced with another one. They changed the title, but the court says it's performing the same function. So it's actually the abolition, folks, is made in bad faith. And then the Basis Conversion and Development Authority, the court said that settled that the directors in government corporation, they only get a dime for every board meeting they attend, and therefore this granting of other benefits is unconstitutional. In fact, remember the old Taralta case, the court said that would be tantamount to giving double compensation to members of the Board of Trustees. And then there was a case where branch clerk of court who was sanctioned Supreme Court. She was practicing law when she was branch clerk of court, and then after she resigned, she handled cases in the branch. The court said that is prohibited under the anti-graft law. The government official is prohibited from handling cases in the office from which he was connected for 1 year, to wait for 1 year. For example, a justice retires, he cannot practice law for 1 year. That's why this, now and then, usually there would be reorganizations in the BIR. That's why these people would be replaced. That's why they said, that's why that's called BIR. Bakit ikaw resigned? Because I received. And so these people, they cannot handle cases before the BIR for 1 year. But they will be dropping by. They will deny that they're practicing tax law. They say, oh, I just dropped by to have coffee with former acquaintances. I was in my first year of practice, I was working with the office of Attorney Vicente de Rosario. I was an alumnus of UST Faculty of Civil Law, and one of the old lawyers was telling me, that's what he told me, you are young, I'm old. Just remember this in law practice. Mas malakas ang bulong sa sigaw. And then these liabilities of person officers. Remember, the civil service law provides that if a public officer makes an illegal appointment, is the one person liable to pay the salaries. That's why the court said these appointees of the mayor also were disapproved by the Civil Service Commission, and now they want to be paid. It said you should sue. Should the one who appointed you. Now, election, will this be a big cut-off point, this registration of voters?
So, pag July 1.
Now, the court has said, well, before that there's a provision election code, and the court said that in a number of cases, if a losing candidate files a pre-proclamation controversy, the period to file a protest remains suspended until the pre-proclamation case is decided with finality. However, the court said, recently, where the grounds invoked are not grounds for filing a pre-proclamation controversy, that rule should not apply. Therefore, they were talking about irregularities in the way the election was conducted. Therefore, the filing that pre-proclamation controversy did not suspend the running of the period to file a protest. And then, in one case, during the canvassing, where you are objecting to the inclusion of certain returns, you can object orally, but then you have to fill up a form and then submit your supporting affidavits. Now, but that form was, until this board did not have those forms. So that the respondent did was to submit his documents in support of his objection when the court said that is substantial compliance. There was an earlier ruling to that effect. And then, as an offshoot of that also, there were objections raised, but then the Board of Canvassers rejected objections, and then they proceeded to proclaim the winner. They never served a copy of the ruling, written ruling, to the lawyer. So the lawyer now appealed to the COMELEC, and the COMELEC dismissed it, saying your appeal was filed out of time. But the court said, no, he never received. He never received the written ruling. But when he saw that the winner was already proclaimed, he appealed. So the court said the petition, the appeal was filed on time. This rule of appreciation of ballots will disappear now with automated elections. So these manifest errors. Now, remember, if a losing party wants to appeal, let's say from the decision of the inferior court or to the COMELEC, you have to pay 2 appeal fees, appeal docket fees. You pay an appellate docket fee to the inferior court or the regional trial court, and then you pay also an appellate docket fee to the COMELEC. If you fail to pay both, your appeal will be dismissed. And the court said the appeal is inextendable. The court said that is jurisdictional. Now, what has happened? Remember, the COMELEC is given the power to change the deadline for pre-election activities. And so, remember, with that power, they have advanced the period for filing certificates of candidacy. Now, what the law provides, a person is not a candidate until he has filed certificate of candidacy. So he can campaign, provided he has not filed certificate of candidacy. But now the law also provides, when you file your certificate of candidacy, you're only considered a candidate for purposes of beating the deadline to be a candidate. So for purposes of premature campaigning, you're not yet a candidate. That's why the Supreme Court said this provision in premature campaigning has now become useless. Well, okay, I think that more or less covers, because many of the decisions were just a reiteration of settled doctrines. So, as I said, I finished digesting all this in my handwriting, but I will have this typed and then later on be made available to you. So that should take about by May. That should be available by May. Meanwhile, I'll also reproduce the 2008 decisions I mentioned today and make them available to you. So, I don't know if I'm assigned to cover anything in commercial. Sometimes they ask me to lecture on insurance or intellectual property. So I think we can just end the lecture on the recent decisions on constitutional law, and anyway, the actual text of this will be eventually made available to you. And I'll be wishing you good luck, because this is going to be a tough examination. And of course, Justice Morales said she will ask questions which require legal analysis. I don't know. Because I said Justice Irene Cortez tried that when she was chairman. After the first Sunday she gave up, because she said the exams from the province, they don't even know the law. How can you require them to make legal analysis? And then I think Justice Abad said that next year 70% of the question will be multiple choice when he becomes chairman. So, so that's where we are now. So let me just wish you good luck. That's it.